A woman in Manchester had lived in her flat for 4 years. She paid her rent on time. She never caused problems. And in February 2026, her landlord handed her a Section 21 notice telling her to leave within 2 months. No reason given. No fault found. Just out. She had no legal recourse. Until now. From May 1st, 2026, that notice is no longer legal. Section 21 no-fault evictions have been abolished in England. And that is just one of the changes that make the Renters' Rights Act 2025 the biggest shakeup to renting in this country since 1988. I end this video we're breaking down exactly what your landlord can and cannot do under the new law, and what it means for you right now if you're renting in England. The Renters' Rights Act 2025 affects 11 million renters and 2.3 million landlords across England. If you're renting privately in England, every single one of these changes applies to you, whether you signed your tenancy before or after May 1st. Let's start with the biggest change, the one renters have been waiting decades for. Section 21 evictions have been abolished, and all assured short-hold tenancies have become periodic tenancies. What does that mean in plain English? It means your landlord can no longer hand you a notice telling you to leave for no reason. Full stop. Before this law, a landlord could issue a Section 21, commonly called a no-fault eviction notice, and give you 2 months to pack up and leave your home. No explanation required. No wrongdoing on your part. Just leave. You can no longer be asked to leave for no reason. Complaining about repairs or raising concerns should no longer put your home at risk. Instead, your landlord needs a reason to evict you. They must use a Section 8 notice. Valid reasons under Section 8 still exist: serious rent arrears, antisocial behavior, or the landlord genuinely selling the property. But they need evidence. They need a legal ground, and they go through court. Landlords will have to give 4 months' notice, while tenants will only have to give 2 months' notice. That asymmetry is intentional. The law is designed to give tenants stability and give landlords time to plan. Now, fixed-term tenancies. If you signed a fixed-term tenancy before May 1st, 2026, that agreement has now automatically converted to a periodic tenancy. If you signed a fixed-term tenancy agreement before May 1st, 2026, it is now a periodic assured tenancy. You have better protection from eviction because your landlord needs a reason to evict you. Before the law changed on May 1st, some landlords put a break clause in tenancy agreements as a way to end a tenancy for no reason. Your landlord cannot use the break clause now. If that clause is in your agreement, it is unenforceable. Now let's talk about rent. This is the area most renters don't fully understand yet. Your landlord can only increase your rent once a year. They must give you at least 2 months' notice of a rent increase. They must use a special form. That form is an official government document. An informal text message or letter saying rent is going up next month is not legally valid under the new rules. And if you think the rent increase is above market rate, you can challenge it. Tenant can challenge increase at first-tier tribunal. You do not need a solicitor to do this. The tribunal is designed to be accessible. If the tribunal agrees the increase is unfair, they can overturn it. Now, bidding wars. It is now illegal to encourage rental bidding wars. Landlords cannot ask for more than 1 month's rent upfront for new tenancies. Lower upfront costs make moving more affordable. Before this law, landlords in high-demand areas routinely asked for 3, 6, even 12 months rent upfront, priced out the most vulnerable renters. That practice is now illegal. You no longer need to compete with other renters by offering more money. Advertising becomes clearer and less stressful. Now, discrimination. It is now illegal to discriminate against potential tenants in receipt of benefits or with children. You cannot be rejected for having children, being a single parent, or receiving universal credit. You must still pass normal affordability and referencing checks, but a blanket no DSS or no children policy is now unlawful. Landlords face fines for this, and the fines are serious. Beefed up local authority powers to enforce the new rules bring with them increased penalties of up to £40,000 for getting it wrong, fines of up to £7,000 for missing the deadline to serve tenants with the information sheet. Now, what's still coming? The Renters' Rights Act is being rolled out in phases. Late 2026, the PRS database launches, requiring landlords to register themselves, their properties, and compliance information. This means for the first time you will be able to check whether your landlord is registered and compliant. Unregistered landlords face penalties. The government has said that the landlord register and ombudsman will be set up towards the end of 2026. The ombudsman gives tenants a free, independent route to resolve disputes with landlords without going to court. Awab's law is also coming, introducing strict requirements on timescales for dealing with hazards such as damp and mold, though the exact date for the private rented sector hasn't been confirmed yet. Wales and Scotland have separate legislation. Everything in this video applies to England only. If you're in Scotland or Wales, the rules are different, and we'll cover those separately. Here is your action plan as a renter right now. 1. Know your tenancy type. If you have any tenancy agreement signed before May 1st, 2026, it is now a periodic assured tenancy. Your landlord cannot end it without a legal Section 8 ground. 2. If you receive any rent increase notice, check it. It must be on the official government form. It must give you 2 months' notice. And if the amount seems above market rate, challenge it at the first-tier tribunal. It's free. 3. If your landlord tries to evict you without a valid Section 8 reason, that is illegal. Contact Shelter England at shelter.org.uk or your local council's housing team immediately. For if you were discriminated against during a rental application because of benefits, children, or any other protected reason, you can report this to your local council. Fines of up to £40,000 apply to landlords who break this rule. 5. Watch for the PRS database launching later in 2026. Once it's live, you'll be able to verify your landlord's registration status before you sign fundamentally. Anything. For the first time in 38 years, renters in England have real legal protection. But that protection only works if you know it exists. Subscribe. Every week we break down one area of law that costs people thousands when they don't know it. Next week, how to get a full refund when a company refuses to pay you back. I'll see you there.